In this video we want to talk about the law and statistics on strikes. In fact, we're not going to deal too much on the statistics on strikes, but we're going to emphasize law. However, the law on strikes. Well, since the Industrial Revolution, laws are in place to make industrial action difficult to accomplish. By and large, governments don't want strike action, employers don't want strike action, and a large section of the labour force don't want strike action. In fact, you could say most, if not all, of the labour force don't want strike action. Strike action is the last course of action. Strike action is detrimental to the status of the company, the business, and hence future employment of the workers. It also, of course, damages the economy. The government will receive less in taxes. There will be more imports as a consequence, perhaps. So strike action is seen as something to be avoided, and all parts of the industrial employment framework, the employers, the employees and the government, all want to see strike action avoided if possible. So it's something that is not desirable. It is something which damages the workers lose pay, they lose maybe damage to company, so the company will go out of business and they will lose their jobs. The company will lose profits and lose its reputation and perhaps alienate customers, and the government loses. So it's a lose-lose-lose situation all round. There don't seem to be really any winners from strike action. So strike action causes a disruption to organisations, trade and the public. Of course, the people who consume the products or the services, the people who want these products and services, they're deprived of the products and services because the company is not working, and this can greatly inconvenience or even damage the public who perhaps need these products. It could be a transport system that's no longer working. Well, people need to get to work. Other people need to get to their place of work. So we can think of lots of examples. So as I said, strike action is something to be avoided. The strike action must be legally conducted and must comply with the Employment Relations Act 1999. This is in the context of the UK. And can I say immediately that we talk about the Employment Relations Act of 1999. We could talk about various acts and amendments to acts, and there will in the future be different legislation, I'm sure, put in place relating to employment law. We're only using this as an illustration. Different countries will have different pieces of legislation. In the UK there will be different laws in the future, I have no doubt. There will be amendments to acts and repeal of certain acts and so on. So it's likely to be the case that the legal framework will change. It changes over time according to conditions and also according to how we see industrial relations and what is most appropriate at the time. So strike action must be legally conducted, that's for sure. All action must be legally conducted in that sense. Where we conduct our lives must be done legally. We can't just make up our lifestyle and inflict pain or inconvenience on others. So we all have to live within the legal framework, and so also do the trade unions and do the employers. So it's quite natural. Official strike action is supported by a trade union. In order for the action to be lawful, it must comply with the following conditions. Industrial action must be regarding the dispute. You can't take industrial action about something else. If the national football team loses a match, it's not right to have industrial action. A company goes on strike because England lost a football match. Well, that would be silly. So industrial action must be regarding some dispute within the company. Industrial action should not be to influence the government about some other legislation, or it shouldn't be to bring pressure on the government about its policy on something. Industrial action should be about a dispute within the business, a dispute between the workers and the management. A secret ballot should be organised, and members must vote yes for a strike action. So there should be a secret ballot. There should not be bullying within the workforce by some employees of others to try and get them to vote in a certain way. It should be a secret ballot, and it should be conducted fairly. There should be safeguards in place to make sure that the ballot is accurately conducted and accurately reflects the opinion of the majority of those voting. The organisation must be notified 7 days before any strike action takes place. Well, this is according to legislation perhaps that is current, but as I said, in the future that might change. It might change to 5 days or 10 days or whatever. The point is, some notification should be given to the company so the company can make some provisions to try and safeguard itself and to ensure that the company will exist when the strike is over, so that the management can contact customers and suppliers and inform all of the people within the supply chain that action is going to take place, the company will not be working, and so that everyone knows, everyone is in the picture regarding what is happening. So it's only fair that the management be told that there's going to be strike action. Official strike action is supported by a trade union. In order for the action to be lawful, it must comply with the following conditions. Individuals refusing to strike must not be disciplined or discriminated for their decision. They shouldn't be discriminated against because of their decision. So if individuals refuse to strike, they should be allowed to work. The union, in calling the strike and calling out its membership, some people may disagree. People who voted no against the strike action, perhaps they want to continue working. Well, is it fair that they should lose pay, should lose income? They don't agree with the strike, now they're forced to lose income as well. Is that fair? Should they be forced to take strike even though they don't want to? Should they be forced to stop work even though they don't want to? So there's an issue. Employees on strike must not be dismissed for the first 8 weeks of a strike unless the strike is unofficial. So employers have to recognise the right of workers to withdraw their labour. Employers must recognise that they can't force workers into work. And if workers wish to go on strike, they can't be dismissed within the first 8 weeks. They have got an 8-week period in which they may take strike action. They may stay out of work for that 8 weeks. If the strike is unofficial, in other words, if the unions don't condone the strike, and it hasn't properly been agreed in a sense between the management and the unions, in other words, the management don't know anything about this, it's just the workers stopped and went on strike for some reason, that's unofficial. The union has not approved the strike. Then the workers may be dismissed, because that's not fair. There's no provision, there's no support for the company. The company can't tell its supply chain that it is having problems, labour problems, worker problems. It can't continue in business. Perhaps it'll force the company to close completely. So the first 8 weeks, if it's official, the company can't dismiss the workers, but after that they can. As I said, this is legislation, and legislation may change. By the time you read this, it may be different. In 2 or 3 years' time, it may be a lot different still. Now, picketing. Well, picketing is an industrial action. This means that workers can stand outside of the company and stop other workers from entering, or try to persuade them not to enter, try to persuade deliveries being made to the company, try to inconvenience the company in every possible way, trying to force the management to concede some issue. Employees refuse to go to work and make a stand outside of their workplace. Generally speaking, they stand outside of their workplace and try to persuade fellow workers who wish to continue working, try to persuade them not to go to work, and try to persuade delivery people not to make deliveries to the company. That's known as picketing. They encourage other employees who cross the picket line to join the dispute. They're always trying to increase the support for the dispute. If they've got a dispute with management, they try to persuade other workers to join the dispute. There are legal requirements that must be taken into account in order for picketing to be a lawful activity. They can't bully or force or threaten. There shouldn't be violent confrontations. So it's an issue that has to be controlled, and it's controlled, generally speaking, by the law. Picketing is only lawful if the employees working for the organisation are taking part in the action. So the picketing, the people who stand outside of the company, outside of the building, outside of the factory, let's say, to try and stop their colleagues from working or persuade them not to work, the people who stand outside, they should work for the company. There should not be people who are politically motivated who come in from outside, from other areas, because that is a recipe for the people who are coming in from outside to do damage to the business, and they themselves are not affected by it. They will still get their income perhaps, or their sources of income will be secured. So it's felt as unfair that people coming in who are not involved in the company, they should not be allowed to picket. They should not be allowed to persuade workers from not going into work, or persuade deliveries not to be made, or whatever. They have no vested interest in it. Their only interest is perhaps in advancing some political idea. So employees from other organisations are not allowed to join the action. They're not allowed to take part in picketing. Picketing must only be used for communicating information. It does not include verbal abuse to anyone crossing the picket line. It should be done in a persuasive manner, but I suppose ultimately in a polite manner, trying to persuade people not to work, trying to explain to them the logic of the case, and letting individuals decide for themselves if taking part in industrial action is a good thing in this case or not. Was the management reasonable? Was it not reasonable? But the picketing should not include verbal abuse. Those on the picket line should not verbally abuse people who go to work, or chant or shout at them or threaten them. Picketing will be stopped if there is an intention to damage property, obstruction to public crossing, noise, nuisance, and abusive chanting. Simply because people are on the picket line and refusing to work because they have a grievance with management does not give them a right to abuse others, to chant abusive slogans at others, or to obstruct perhaps ways in which transport needs to travel, or block public roads, or inflict costs on people who are not related to the dispute. And they certainly should not be allowed to damage the property. That is criminal, and the law makes sure that the picketing must be done lawfully. So, by all means, workers have a right to stand outside of the organisation and persuade their colleagues not to work and persuade deliveries not to be made to the company and try to maximise the inconvenience to the company. But it should fall short of abuse of people who wish to work, damaging property and so on. No strike agreements is a method adopted by organisations to restrict employees taking industrial action. So sometimes when people get a job for a particular company, they have to sign a no strike agreement. In other words, that they agree not to go on strike. They may have a dispute, they try to deal with the dispute without going on strike. Of course, you could say, well, this of course weakens the position of the workers, because ultimately the workers have a right to withhold their labour. It's not a slave society where people can be forced into work. And people need an income, and they may need the employment. So forcing them to sign a non-strike agreement may be seen as coercive and unfair. So it could be argued two ways here. On the one hand, the employers want continuity of employment. They don't want the business badly damaged by strike action and perhaps even go out of business. They don't want that to happen. That's on the one hand. On the other hand, the workers do have a right to withhold their labour. They do have a right not to work if they so choose. What the no strike agreement says is, should the workers exercise that right, then they will lose employment in that company. Now you could argue then that, well, the employers have a right not to employ them. But then also you could argue that that's coercive, that's forcing the workers. So it could be argued on all sorts of fronts, and it is hotly debated in the press and on the media. It's all the time there are arguments to be made for and against, and it's difficult to resolve this. It depends, I suppose, ultimately on political points of view. No strike agreement is made by employers and unions in a collective agreement. So sometimes the unions and the employers agree to having a no strike agreement. But of course, if industrial relations become so bad within the organisation, then a strike is almost inevitable. Workers perhaps can't take it anymore. They can't understand the management, or they feel the management is being abusive or not fair, so they will withhold their labour. Under the Trade Union and Labour Relations Act 1974, a no-strike clause must be expressed in individual employment contracts. Now, as I said, laws change, so we're not going to get involved in current law or past law or whatever in these talks. Just simply saying that under that one, a no-strike agreement was expressed in individual employment contracts. So when individuals took a job in a company, they signed a no-strike agreement. And it was a very controversial thing to do, because the unions saw this as the workers giving away a fundamental right, the right to withhold their labour. But as I said, these laws almost come and go. They'll be superseded by new laws, and the next government will bring in a new set of laws again, new set of amendments, and so what we need to do is really check out what is the current state of law. But we're not going to do this in this particular video. But we can see here that the idea of a no-strike agreement can be traced back way before 1974, but in 1974 it was institutionalized. It was made law that anyone taking a job would automatically sign a no-strike agreement. They would not go on strike. The no-strike agreement restricts employees from taking industrial action and limits unions and employee power. So it is a great restriction on the trade unions, which may mean that the management have more power to implement policies that perhaps are not in the interest of the workers. Or it could be that the management revert back to the bad old days in terms of employment and the abuse of workers, getting them to work longer hours and working from home and working at the weekends. And so it's a very difficult situation. Legislation has provided a structural framework for industrial action. So legislation is important because it provides a framework within which industrial action can take place. The trade unions know what they're allowed to do because they know the law. But the employers know as well. And really what legislation should be doing is trying to get both sides to work fairly, to work honestly and openly and fairly with each other, so that issues do not escalate and do not become big and lead to strike action. Laws are in place to protect employees and employers from industrial action and to ensure procedures are conducted legally. So the legal framework is to protect workers who don't agree perhaps with the strike and want to go to work. They should be protected. They can't be abused. They can't be discriminated against. They can't be threatened. And the company itself shouldn't have its assets damaged by the strike. They shouldn't have windows broken or property damaged as a consequence of the strike. So there's a legal framework within which industrial action can take place. And both sides, the trade unions on the one side, the employers on the other, they know what the limits are because they know the law. Since the Industrial Revolution, laws have refined the ways in which industrial action is conducted. So going right back, there has always been attempts at trying to introduce laws to provide a framework. Some of the laws were very anti-trade union at the start. Combination laws, trying to stop people forming combinations, forming groups. So if employees were formed into groups, they were seen as somehow dangerous or anti-business. And of course, law at that time was made by the business community. Most of the laws were enacted by people who were in Parliament and who also were involved in businesses. It was only when the trade unions became more and more powerful, and mostly because there was an extension of voting to, if you like, people who were not landed or were not big farmers or industrialists or powerful people in the society. When the vote was extended, more people were able to vote for politicians, and the politicians had an interest in trying to meet the requirements of their electorate. And in that sense, industrial relations started to change. It started to change as laws which permitted industrial action started to be implemented. But it was a slow process. The trade unions came into existence back in the 1800s. There are examples of trade union type activities back into the 1860s, 70s and so on. But it was around the 1890s up to the 1900s that there were more concerted efforts made to try and form trade unions. And it was seen as quite a dangerous political movement by the establishment, by the people in Parliament. They were afraid of Karl Marx and the writings of Marx, which were published in the 1890s. They were afraid of European socialists, Rosa Luxemburg and people like that. So there was a fear that this extension of voting and the extension of workers' rights would lead to somehow a major collapse of the country. So there was a lot of opposition to the development of trade unions. The National Office of Statistics maintain records of industrial action in the UK. I'm not going to get into this. I'm not going to talk about it because the figures simply show that there's been a decline over the from the time of Margaret Thatcher onwards. There has been a sort of a continuous decline in industrial action. There might be some peaks and some troughs and so on. So I don't think the figures are that particularly useful, other than saying that the climate for industrial relations has changed. Now people are more cognitive on both sides of the divide. Management is more aware of the need for corporate social responsibility. They're more aware of the image they project. And if they're abusing their workers, that does not go well in terms of their marketing position and their image within the community and within the economy will be damaged. And likewise, the trade unions are more aware that aggressive picketing and industrial action for small issues, these do not have the sympathy of the vast majority of people. So there's a greater awareness on both sides, and I think that is the outcome of what's happened in the past. The government statistics on strikes measures things like the frequency of strikes actions in the UK, how often do strikes take place, the size of the strike and the duration, how long do strikes last and how big are they, how many people are involved. Strikes in recent years have declined due to stricter laws in place to protect employees and employers. So the legal framework is much more refined and covers a wider range of issues. But essentially it's also down to the fact that employers and trade unions are more enlightened. They now know more fully that the responsibilities they've got to their members on the one hand, and the employers have a responsibility to their customers and to their shareholders and also to the wider community to create employment and sustainability, and they have a commitment to the environment. So there's much more awareness now, and there are many more issues to be taken into account when running a business. So the management tend to be more aware of what's required. And likewise, the trade unions are much more sensitive as well. The trade unions have adopted almost new roles in not just safeguarding the rights domestically of the workers and trying to advance the situation of the workers, trying to advance their conditions of employment and so on, but also in education, to educate the employers, educate the general public, and make us aware also of what's happening in other countries, which is extremely important. It's not simply good enough to think that there are cheap products in the shops. The cheap products in the shops may have been imported, and they're only cheap because the people who made them in other countries are working under dreadful conditions, and the trade unions highlight this. Likewise, the employers have adopted, as I said earlier, greater responsibility for the environment, greater responsibility for the welfare of their workers, providing training and opportunities and motivation. So there's a different climate almost for industrial relations in the UK in the early part of the 21st century. That's all I'm going to deal with in this session, so let's leave it at that. There are some sources that were used in the compilation of this session, and that concludes the video. So thank you for watching.